Hey y'all, I'm Ada K. And I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Well, hello and surprise! We actually have a court feed. They are actually showing her trial. And I just got off live. So we're back. Let's go. I'm I'm not going to delay it. We're going to hop right on in. I'm sorry guys. That's the way life is. Here we go. Uh this is crazy. I can't believe they did this. All right, Sarah Boone representing herself in trial today for her hearing. And Court T just started this an hour ago, so we're a little behind. I'm sorry, but that's the way it is. It was canceled from the hurricane. Well, what is this that they're playing right now? Okay, let's see what this is. And then I get the wrong meal. Let me get it up and going. I'm in shock. Yeah, this is the judge addressed several handwritten motions. Yep, this is today. Yep, we're live. We're doing it. I'm going to make a phone call because they screwed up my dinner. They're taking their time. Sorry, guys. They're not answering. I'll have to call them later. I'll have to call them later. So we are here. Woo-hoo. Hi, Campfire for Life. Hi, Colleen. You were the first two to join me. You're so awesome. Okay, I let my mods know. So we're good to go. Where's Miss Andrea? Oh, I need to get a hold of her. So we'll see what all is going to happen now. But I'm glad I saw it. I wish I would have seen it earlier, but we are here. I'm going to.
Great information.
Okay,
There we go.
very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial dated July 18, 24, received July 29, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need.
That's
So
your
I understand
problem.
So you're telling me at a later date once I have that information?
Not his.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to, With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for state?
Is there a dog barking? Sounds like a... Oh, that's my girl. Shit.
Standby counsel.
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
Oh, snap. Snap.
Do you have any other questions, ma'am, as to the court's rulings this morning?
And so it begins.
Did not forfeit my right.
I wish they'd mic her.
Judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to having an understanding before you take someone's right to it.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta
She's
is
in
not applicable to
over
your situation,
her
and
head.
it's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence, or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. In my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Ooh.
I believe, in my opinion, the order is erroneous, and
Y'all remember? Oh, hot in my ears because I have to turn it up, and now I hear me way too much. Y'all remember what I said about the word I believe? You believe it wrong.
after I reviewed your 16-page order, there are quite a few incorrect.
We just started.
And some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's August, right?
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days.
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful
Haley
that
Mao,
you have not
Nikki Stisai,
reviewed some of the
Elizabeth.
documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed you, but some of it may have been reviewed based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense to me.
That does make sense,
Yeah.
and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen.
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Go ahead, sir.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. Then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
We want to see.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So the option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I don't know if my investigator and I are able to collaborate prior and review and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here, just like an evidence viewing at the sheriff's office or elsewhere where council just identified. And
You're
I
what?
cannot bring you anywhere else other than here,
You're welcome.
and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could.
How many have you been to?
With the media being involved in that.
I understand your position. And again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, if the USB drive or the after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right. I mean, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion, if there is a discussion to be had about plea offers. One of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
She needs to take a plea deal.
So would I be meeting with the digital?
She needs a plea deal.
Or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to whom, what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he had furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically
Yes.
as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with, the implementation of your USB drive.
Okay.
option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by US mail?
Mhm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
Yep.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, if I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer.
Please, no more letters.
By me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or she'll be the contact person. So the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do.
Okay, everybody. There was a fiber optic cable cut yesterday near you guys. Okay. I'm very sorry for the interruption, everyone. We will hopefully be back up and running in just a matter of moments. I am not quite sure which stream they had up, but let me see if I can go and find it. I'm Sneaky, everyone. And if oh, and Braxton is here as well, so hopefully Braxton will get things. Braxton is much better than I am, so this is more hopeful of an effort. No. Hi, Braxton.
Hello.
How's life? How was work today?
It was actually fantastic.
Good.
Ah,
You were all over the place,
just jumping
apparently.
in. Right.
3 or 4 stores, you said? 4 stores.
4 stores today. Yep. Yep. Just got home.
Hello, Braxton.
Hey, Diane. How are you?
I'm doing all right. I just lost everybody all of a sudden. I'm like, I don't know where they are. We were, and then we're not.
Right.
So I just kind of went out and then turned around and came right back in to see what is going on.
Yeah. Ada's having some issues, unfortunately.
Hey, well, due to bad weather, I don't know what kind of internet we're going to be having the next few days around here. Because we got hurricane coming in.
Okay. Hi, Diane.
Hello, how are you?
I'm doing well.
Wonderful.
I am just looking at some of the different layouts. We're watching Braxton fix some things. You look very nice today.
Yes, Braxton, you do look very nice today.
No, I was talking about you, Diane, but Braxton also
thank
does
you.
look very nice today.
It's amazing what a
Right.
little bit of paint will do.
I'm gonna hop back off, guys, but hopefully. Oh, we can't hear you, Ada. Not quite.
I know.
Y'all are having fun. Look, Braxton.
Perfect.
Ooh.
There we go.
Wow.
Okay, guys. Y'all have fun now.
All right.
So your internet just completely died. Got it.
Yeah, but my son still had connection.
Oh, well, I don't know how much I'm
Sounds
going to
about
have
right.
here in a while.
You're good. It's me.
What was the lady's name that was just on here?
That is Miss Sneaky.
Okay, Sneaky Heeky?
No, my hearing aids, I'm having a problem. I can't hear me or anything. But anyway, Sneaky Side. I call her Sneaky Pants, but her name is Sneaky Side.
Well, don't feel bad. I could not hear the Sarah, S-A-R.
No, they don't have a
Boone.
mic. You're doing the best you can.
Really?
We have a deaf person who's watching. Braxton, I don't know what's going on. We lost. This is pissing me off.
It's better to be pissed off than pissed on, as my daddy used to always say.
So I don't know what to do.
Well, it appears to be fine now.
But look how low it's running.
Usually
it's up here.
Well,
okay.
It is what it is.
Well,
we'll get this going again.
I can't be on very long anyway. I have got to get some invoicing done. Or either I'm going to be begging Braxton for money since he has a job. I'm be begging Ada K for money since she's got a man or sugar daddy somewhere. I don't know where, but somewhere, I'm sure.
Okay, well, this actually, let me see if she's going to keep watching because this is going to go another hour.
Yeah, because I can't be on it that long because I have got to get this to these people
Don't
or
worry
they're not
about
going
it.
to pay me.
Don't worry about it, babe. Don't worry about it. Love you.
All right.
Have a good one, Diane.
Bye. I will. I'm going to sit in here and, do the thing.
All right. I am going to jump off for a couple minutes. I will be back.
Looks like you're laying down in bed.
I'm laying down in bed because I had to jump on.
That's okay. We're all good. Thank
I
y'all. I'll
show-
get it on again. We're
I
good.
show up in chat and you have tech problems. See how you are?
Well, actually, the internet went down this morning
Oh.
throughout the whole shop and the whole block. And someone said that there was a fiber optic cable cut the little town a couple miles down the way, and it took out almost a whole county.
Wow.
So we're it is what it is.
Yep.
Okay, love.
I'll be
We're
on
back
later.
on.
Physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order be unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections.
Hey, Cindy.
And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, if I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get that.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could file that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have a laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are enclosed, the laptop is closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 917, if that has to be changed, and I okay to do that?
I'm trying to set deadlines now, ma'am. And that would give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very worried to make these type of deadline.
Well, we're setting them today.
I understand. So the third is.
If I hear I understand again, I'm going to lose my crap.
So the 17th would be 2 weeks later.
Oh,
Tuesday,
definitely.
And that is me coming with my objection.
That would be you filing your objections in writing with the court.
Definitely acts dumb, but she ain't no dumb
And to
cookie.
the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
By me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Boom. End of discussion.
So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Good for you, Judge. His patience is starting to wear thin.
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I
I
understand,
cannot answer that
yes.
for you. That would
That's
be
going to
me
be my new
providing
favorite
you
phrase.
legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. Those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay, and if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines.
Yep.
So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable, I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go.
Well, that seems to be a personal problem to me.
For me to accept this date and then not be able to meet it, what happens when that happens?
A very big personal
I can't
problem.
answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Oh, poor baby.
Well, I'm with the court, so.
She's
what
all
is it that
alone.
You all are trying to do in order to expedite this even more than what it's being expedited. I'm guessing I agree with September 17th.
Okay. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Hint, should you choose to put on a defense? Meaning, girl, get your shit together, please.
So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses.
I want a t-shirt that says, no more whining, Sarah.
May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Who is it that I need to speak to in order for this?
He is
You may
not
need to
your
inquire
lawyer.
of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
Can
Ma'am.
I ask your contact names for the jail?
Give us 1 second.
Please, and also because of the court's error of.
Yep, exactly, Haley Mouse.
Information that you're referencing to the incorrect.
All of y'all are right.
Could you please provide me a copy of
Should have
that
played
also?
nice with your lawyer like you had the
What is it that
chance.
you're asked? Which, the protocol, ma'am? That was what was most
Oh,
recently
I'm
said.
wrapping cords.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What did I do? Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
Ronnie, it's me saying I need a margarita and I can't drink them. My friends know if I say I want a margarita, it's get me the hell out of there.
To locate anyone, I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment.
Her whining is relentless, y'all.
Your understanding of a meeting that I would like to have with the captain, so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
No, it'll be tomorrow because of time of court. By the time they get her back,
And it's not
it
gonna be
goes through their process of
Sure.
strip
My
searching
suggestion
and all that,
is
which I know I just
that
lost my
days
monetization, but I don't know.
that the specific evidence
Once all that
identified by the state
happens, she
was
loses,
provided to her.
she
So,
won't get
for
there,
example,
get
the physical
enough
evidence,
time.
which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
No,
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes.
And I
that's
just-
why I'm trying to make everyone aware
Knock
prior
some
to all of this
sense into
to
her.
understand.
I'd love to knock some sense into her.
Not having access to them.
I know, I'm trying. Okay, can't say that.
Not having access to any more other
Can't do that.
basics, fundamental basics.
I just got something in Discord. I wonder if I'm getting my hand smacked.
When the time comes, should it, why for good cause, I'm stating my good causes now, if not there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for a good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Mr.
Okay, all right. I will set a deadline for the review of September 26th.
Is the review that you're speaking of, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in. You can stay at the podium, sir. No, just the podium, Sergeant. If you could raise your right hand, Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Thomas Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk is going to swear you in.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane,
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession from this Boone, where the courts needs, if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Don't try it.
Mr. Casey, could you please make known to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
Y'all.
I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
My only question is, Mr. Lane, do you know when you
Dude. Nope. No, 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 no. Nope.
Mr. Lane, and you want to, it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
one thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC. If that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000.
Woo!
Investigative costs and for travel related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lake, thank you so much, sir.
Yes, sir.
All right.
Judge Payton,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
my
there.
side also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that
This
the
ought to
deputy
be
has not
fun.
already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document, proposing the dates for today's hearing. And, I guess it was some type of notice. That's what, please, that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it? It should be. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
Oh. I have a drawer thing over here, and I gotta tell you, it's a hot mess, driving me crazy. When I moved everything in and we were working on everything, we were going pretty dang fast. So, needless to say, things got a little bit messed up.
Ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
I have so much equipment in here, y'all. I have so many gadgets and things. I can't remember where I put what. Ah, that's the drawer I made. So what are y'all thinking about all this hot mess? I mean, this is hot mess. Hmm. Y'all,
Mr. J, if you want to approach sir to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, counselor, and just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, of the hard copy discovery, you've advised me multiple times seeking to use a laptop. I have written correspondence from you asking for a laptop.
mm-hmm.
That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now, or are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you. You have written letters, ma'am, specifically asking for a laptop.
And she got it.
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates in the entire compound.
So you're screwed, my. Oh no, not again.
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent
Braxton, my dear friend, we need to get involved. I don't know what the hell is happening.
Case documents at my phone. Help me understand, please, for future reference, so I know how to approach. By my statements that I made to you, questions were not asked in order for you to come to the conclusion that you are coming to, that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued, like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me in prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Berrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything. Just like my letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not.
Sorry. I know that's not very nice.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week. So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
And she has a right to that vacation.
What would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern, as in Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers boxes
Oh.
that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
if she moves Ori Tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
She's brutal.
So if she wants to Ori Tennis, which means oral motion, move to release those 2 exhibits, the state has no objection. And sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So
She's going to keep pushing until she gets the hard copies.
Ma'am,
I wouldn't want hard copies.
recommended a
People can steal them
position
and take them and read them.
for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to the
Yes,
jail
should have been that answer.
by the captain and whomever?
Yes, thank you, sir.
no objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those bankers boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:40.
Okay, guys, I'm going to stop for a second. 2 banker boxes is all she has for her case out of 8 attorneys? My gosh, y'all, that's not a lot of work. They had 100 of them, almost 100 banker boxes for my ex. Okay. I mean, 2 banker boxes is like nothing as far as evidence. Just saying, y'all, that ain't a whole lot. If you've ever seen anybody going into a murder trial, they have trolleys of banker boxes, 4 to 6 on each one. Sometimes I saw as many as 9 banker boxes per trolley, and they had 4 trolleys. I don't know why that did that, but anyway, so this to me is not a big deal. There's not a lot of banker boxes here. This is not a lot of evidence, personally.
Provided to you, if you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert.
Here's the thing. She cannot share that computer with anybody in that prison. There's a lot of inmates in that prison who are smarter than her, who are probably trying to help her with this, right? She can't sit there with them and let them look at it with her on that laptop. They can't be near the laptop at all, unless the judge orders somebody to. So, she wants the banker boxes because if she has banker boxes with the paper evidence, there it is. If she has those 2 little boxes there, then she can pass the papers around or give it to somebody and read it and tell me what you think type thing. She can get more help. because they can sit and read it in a cell. She can give it to somebody, then give it back to her later. But with a computer, she's screwed,
So if she wants to ori tennis, which means oral motion,
in my humble opinion.
move to release those two exhibits, the state has no objection. And it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her.
Sure.
if that's what she wants to do.
Ma'am,
don't
the
wanna
state has recommended a position in an attempt to get you these hard copies.
Oh, we've already
Is that
heard
something that- Wednesday, August 14th at 1:30, if we need to address the jail's
Oh my gosh, they're not that
position in
heavy.
taking hard copies, if Mr.
But he
Lane's
does know
unable
how to lift
have it
properly.
delivered.
He lifted from
Mr.
his
Lane, you had
knees.
advised earlier when Ms.
That
Boone
one
had
was
inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are,
Right,
I'm
Cindy.
going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay, all right, thank you.
Your Honor,
Yes, ma'am.
what would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what if any protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence.
Was that August 14th or September? I think that was
As
August.
of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday? That is the 9th, ma'am.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Your Honor, what time will that motion be?
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey.
Oh my
who's here
God,
this
I know
morning,
somebody by the name of
Stephanie
Giovanni.
DeJesus, Sonia Robinson,
8:45, you think?
Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard
It
copy?
would be. That's 7:45 my
put that in
time.
the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may,
Thank you,
I don't know
Lindsay.
if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
What did you say?
How do I go about getting a copy of my phone or utilize
I had to hear that question. Had to hear the
the
question.
state directly?
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
That lady was like, did you see this woman with the long hair? She goes,
So my understanding is there was an imaging done on your phone with software called Cellbrite, and that
oh,
part of the digital
Cellbrite.
software has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and the KAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mere download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously
it
your
was.
entire
I think
phone,
we're about an
however
hour
many
or 30
gigabytes it
minutes
is not going to just come into evidence. Like you said,
We just got about 5 minutes.
not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
7 minutes.
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Oh my gosh, y'all.
I've not seen any of that.
We are going to make sure that that is taken care of.
And that,
What was
just
that
as
date?
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now if I don't have what I need or I'm looking for, how do I go about?
Ma'am, these 2 men deserve the biggest cigar, beer, whatever it is that they love on this planet for the patience they have exhibited to you. They're not here to school you on how do I go about. If you can't find something you think you should have, then what you do is submit a request to the courts to request it from the defense. Or you can even write a letter to the defense and say, we are missing said information. Do you have it and have you turned it over? And if they say, no, we don't have it, we've not turned it over because we don't have it, then you're screwed. You're wearing my patience thin as freaking hell.
Because of legal matters, but
Hey, Brett.
I need to write a motion. I don't know what to do do in order to finally
Does that offend you if I call you Brax?
mirror download of my phone.
Yes.
Braxton.
Brax
You like
works.
Super physical.
tired IT
So
Braxton.
again, that is gonna be something that requires.
You
an
don't
expert.
get to play with your phone, my
And you
dear.
get a defense expert.
Good
who
one,
gets the
Rusty
case
Dog.
for it. Then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did. And you all can work with that image.
Why would you do
If you're
that?
going to
That's a
work-
waste of
If you
your
don't
finance.
already, on those thumb drives that Mr. Lane has,
expensive as
if you don't already have the full extraction and not just the PDF timeline of your phone, you're gonna make sure that that is provided.
Why is he telling you how to get what you need?
So that is not able to be included
Oh.
in the other physical evidence that you will supply.
No, what I'm saying is, there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of miscommunication, so on and so forth. And then there is the
Mind blown.
actual ginormous file that is read.
Look at
with
Bob
the
back there. He's like, I'm
program.
so over this.
And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And
Oh,
if it doesn't
wait.
work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes, I am grateful for your information. Just to clarify, please, during the physical evidence of me doing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone, of the phone.
Oh my God, woman.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing you a letter. I don't know when I write a letter, how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because
How does she know how long it takes to
correction,
post
but
to the
I don't
clerk's
believe updated.
website?
It's been updated
No,
now.
I mean,
What?
on the clerk's website.
I can't speak. to
How
what's on
does
the clerk's
she
website.
know?
I know for the
Pause it
purposes
real
of my
quick.
records and getting information to you, that clerical error has been remedied.
God only knows how she knows. I don't know how she knows.
Do you have any other
Right?
suggestions? Since I do
Jeez.
not have internet,
Give me
was my
a
only
break.
possibility to correspond with you via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I will
This
do it.
is
You
just
saw the
painful.
motions that you made reference to at our last hearing, that you had 5 of them. We set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to
And beyond.
any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on.
You're not gonna have
technology,
internet access.
Am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadline. for the
She gets
addresses.
internet access. All right.
Your Honor, for the love of our precious Lord Jesus, do not throw your assistant under the
Oh
bus.
yeah. Oh yeah. He just.
You may have just lost your freaking assistant.
Yeah. Right.
Now, she does have rights because she is representing herself to certain access.
Mm-hmm.
But, oh, hell, you better give a bonus to that assistant after this shit.
Uh huh.
It's 2 hours and 2 minutes. After this, you better give her some money. You better give her a spa day, maybe a weekend vacay, something for dealing with this character. I'd freaking quit.
Yeah.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or the portal or whatever it is I might be attached to in order to receive notices to be populated here?
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been
She
filed
can't
with the
get
court,
off of this.
including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
Grateful, thank you.
Yes, ma'am, thank you.
I have sung 3 different female parts on that song, and I have signed it. It is holy Moses. Oh, where's a drink? It's after closing. I can have a drink.
Yeah. Okay, I have a legitimate question here. Is she playing dumb, or is she nice words?
Oh, this woman is manipulative, passive aggressive. This bitch is smart.
But there's a difference here.
There's intelligent smart and street smart, and she's somewhere in between the two. But I will tell you, she's used all right. When you're in prison, there's a lot of people that have done white collar crimes who are in the criminal world, even lawyers. And there are people in there who are very smart and very good at resourcefulness and library books. And they do have access to a law library. So if she had paper copies, she can then, here's your section, here's your section, here's your section, and she can get help. But if it is on a computer, nobody can help her.
Mm-hmm.
So she's smart. I know this from my ex's personal experience. So she's not a dumb cookie by any means. But she's stupid. There's a difference between intellectually smart and still being stupid by running off all your attorneys. And I don't want to, well, okay, I understand, Your Honor, but it's like, no, you chose this. We are not obligated in any way, shape, or form to give you instructions on how to file this, where to file this, how to contact us, and all of this. You want to be an attorney? Go. We treat you equal as a lawyer.
Yeah.
Yes, Colleen. If she has a laptop, she cannot share the screen with other inmates.
Nope.
She has to sit in a room by herself from 8 a.m. to 4 p.m. That is like a 9 to 5 business day. And now the only concern I have about this is how many people have passwords and access to that computer, because she's going to have a password and they are going to have a password, i.e. the prison. How do we know that that laptop is secured in a way that somebody can't go in there and do some funny things to some of the documents?
All right. Well, I can answer that.
Yeah, I figured you would. I asked you.
Yeah. So honestly,
They have a protection program on it.
So it's going to be locked up in a cage. Like, it's going to be behind lock and key.
Yeah, but how many
people have
access to that lock and key?
By the sound of the court, very few. However, if we ignore the fact that it's behind lock and key, that laptop is going to be so locked down you won't even believe.
But what my
This-
point is, I know you're right, but
Mhm.
she can argue this doesn't work.
I can
Your
explain it.
Honor."
Oh
Okay.
wait, what doesn't work?
Oh, she can sit there and say, "Well, how do I don't know if it was properly secured. So the information I had may have and could have easily been manipulated, and the courts refused to give me a hard copy to look at. So I have nothing to compare it to. And it doesn't matter who has a key. Somebody has a key. So there's reasonable doubt."
So here's how we get around that. If their IT department is any good whatsoever, which I like to hope it is, personally. Because here's the thing, a lot of IT departments are pretty good.
It depends. If it's their equipment and their programs and their stuff, yeah. But if there are people who in prisons who get iPads and they can't even get help on the iPads because the IT person that supplies the help for the inmates stuff
Mhm.
is barely a high school graduate who thinks he's a techie. There's no guarantee that she's going to have someone like a Braxton.
So I'm a high school dropout.
I know you are, but you know what I'm saying, though.
They have decent IT. Like, here's the thing.
And Braxton, you are not the normal cookie.
In the IT world, I'm slightly above average.
I was being generous to them.
No, because I still have a lot more to learn. But here is how you would do it. So they have the logbook in and out, obviously.
Mhm.
However, on that computer, there's going to be tracking software. It is going to track exactly
Who did what
when someone logged in, where they logged in. Hell, I would have it take a webcam picture
Mhm.
every time it's opened. Like, these are all
Yeah.
safe measures that are easy to implement. Not to mention, it's going to be encrypted, likely with a password only she will know. So, and that encryption is going to be able to be to the point where that they will be able to confidently say, no one else has been able to get into this. Here is why.
Well, I believe you. This is Colleen. This is a good question. Did she choose it, or did they say enough with enough and she's stuck with being her own? I would say 50-50. She had a choice to stay with the attorney, but the attorney asked to be removed, and the judge could have maintained and made that attorney stay. The judge can tell the attorney, guess what? You got the job.
Mm-hmm.
But she also said, I want to call her Susan. Sarah said, I don't want her. I'd rather be my own than have her, basically, right, Braxton? I mean, that's pretty much the easy version of this.
Yep.
So she thought she was going to get another attorney. And they said, nope. You said you'd rather do yourself than to have her.
Yep.
You made the choice. We just honored that choice. 8 attorneys. That was what? 7 of the court appointed and 1 paid.
Yeah.
That's bad when a paid attorney quits.
So, real quick, everyone is going to get a quick tech lesson here.
Okay. I thought we were going to get in trouble.
Nope. We're getting a little tech lesson.
We need to get you a light lesson.
I'm actually working on that right now.
It's too hot. It needs to come away from you. It's like too hot on your face.
So it's the screen in front of me. I'm trying to download the screen dimmer that I use.
Okay.
Now, here's the thing. The reason everyone's getting a little tech lesson is We are going window entire screen. Here we go.
Oh, by the way, I got a home stream deck.
All right. If you ever see one of these,
I'm going to just do it this way. I'm going to do it this way.
yeah. If one of these ever comes up, ever, then you click don't run. Never run it. Always don't run.
And how did you get that up there?
That is a sketchy program I downloaded from the internet.
Why would you do that? Who were you getting ready to destroy?
No. It is literally just the thing that lets me dim my screens.
Oh.
It's an app I trust, but Windows doesn't like it.
Oh, but you know how to take care of that.
Yep.
Yeah. I got a hold of Stream Deck and they said there's something weird here.
Yep.
We did everything that we did right, so we did it again. They had me run this program and sent. I still have the zip file. It's a support zip file, and I sent it to them. And now I don't know. I haven't heard back from them.
Well, if they're saying it's a weird problem and they need you to start running things, they have no idea. You have managed to stump all of them. So congratulations. I didn't actually think stumping Elgato would be a thing, but you did it.
Well, they said that they didn't. They thought, well, if it was attached to YouTube, then they had a fix. So we uninstalled YouTube from all the way down to the BIOS, they said. And then we uninstalled the stream back all the way out of my computer. Uninstalled the dang. And I've already know how to do that. He goes, man, you are above average for anybody that we work with. And I'm like, thank you.
Why do you think I'm so happy to work with you?
I'm
not even kidding.
Am I that easy?
Yeah.
I know I've been easy before, but damn. No, kidding. But they said, okay, let's reinstall it because we took everything off the computer. It should be fine. Reinstalled it, and it just like 250 went. It went like that. And I said, you have no freaking idea how many of these damn tabs are on my freaking computer. And he could hear the click, 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 click. 5 minutes, click, 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 click. He goes, ma'am, I'm going to have you run this thing, and we'll get back with you. And the thing is I've had this on my computer a while and never had a problem. I told you. And I said, we just ran a virus sweep and everything. And everything's good with the computer overall. It was in really good shape. And then this happened about 2 or 3 days later. He went,
Why do you think I told you just contact them? I can't help.
Y'all,
I couldn't do it.
Y'all, hell has frozen. Braxton can't help. Oh my God.
No, there's plenty I can't help with. But here's the thing, and here's the mark of a good IT person. If we don't know how to do something, we find you someone who
does.
Can.
Right. They don't screw it up.
No, exactly.
Well, I tell people, I said, look, I only speak on what I know. And if I don't know, I don't speak on it. So if I'm speaking on it, you just trust me. Now, sometimes I can learn something wrong, and that's an innocent thing, but I'm not going to sit here and blow smoke up your butt. Yeah. If I know it, I know it. If I don't, I don't. I'm too mature now. My ego has shrunk quite a bit. You know how young people, sorry, Braxton, but.
No, yeah.
Yeah, there's a friend of my daughter's who she knows somebody who knows somebody who knows somebody who he's like 20 years old, and he said that there was a bill that was in the Texas Senate or government, whatever, and it was tied, and he was the one that cast the deciding tie-breaking vote. And I'm like, you dumbass. Just because you were a freaking, what do they call it? An intern of an intern in high school and you knew that this congressman or somebody, there's levels of things like that that you go through and people, what? Nobody knows, Sarah. No, I'm giving it a different example. I'm not giving the full situation. It doesn't apply. But young people now, and not just young people, old people too. There's a lot of people out there who sit there and they have about yay big of information, but they want to make themselves feel good, so they blow it all up.
Yep.
If you're going to blow up information to make you look good, you damn well better know it can't be reviewed it because the person who breaks the tiebreakers is the House. What?
Yeah.
Who does it?
Yeah.
Who does
Exactly.
it?
The House.
Who does it? No. Who does it in the House? Who's the head honcho of the House? Oh God, Braxton, come on. Who's the head of the Senate?
Speaker of the House, right?
There you go. They're the ones that cast the tie-breaking vote.
Yep. You know, it's funny. So with IT, if it's a complex problem and you need to save face to make the end user feel better, honestly, the amount of times that I have given an answer that sounds so confident, that was total bullshit and everything is on fire. Yeah. You just hope that they don't see through it and freak out. That's where I'm at with those. But
I just saw where American athletes who get a gold medal in the Olympics gets $38,000. But in Japan, it's like $100 and something $1,000 US dollars.
What? Well, here's the thing. How many gold medals did we get this year?
Oh, we have a lot.
Exactly. They can't afford to do that.
Yeah,
Like,
that is.
They have to split that up among how many?
Yeah, I know. That is so true, y'all. That is like true. I got this. Okay, right now we have 20 gold medals, 30 silver, and 28 bronze. We are at 78 medals. Now, Team China is ranked number 1 because they have 21 gold medals. I'm like, I don't know. What is the total medal count? We are number 1 in total medal count by almost 20 medals.
Oh, yeah.
But China has 21 gold, 18 silver, and 14. Japan is not even on the list. Do you know why?
The one I'm looking at right now.
10, 5, and 11, they got 26.
Well, but if we look at the gold, it's half as many as the U.S. right now.
Yeah.
Why'd that go away?
So Slovakia only has 1. Portugal has 1. Indonesia, Grenada, Egypt, Cuba, Cabo Verde, Austria all have 1. Everybody else goes up, but 1 medal in general. Well, no, there's a lot of countries that only have 1, but yeah, we are 1 gold medal away from tying in 2, well, depending on what China does. But anyway, so God, I cannot believe this is my 3rd live today. But we got it. Do you know the first live is over 1,600 views on YouTube, and other ones make it over 1,700 views?
Really?
And they did a raid on me this morning.
Nice.
Broken Baker. Yeah, we're almost at 1,700 views on Sarah Boone's motion hearing this morning.
Oh, yeah.
I can't believe that. Oh gosh, somebody go and view it, please. I'm at 1,666 views. I'm not that superstitious. I'm being silly. So did you see the thumbnail I made live this morning?
I was listening. I didn't watch it. It sounded like a lot.
Where is it? There it is. I'm going to embiggen it and share the screen. Braxton, thank you. Really? Really?
I don't know what you're talking about.
Uh-huh. What you talking about, Willis? What you talking about, Willis?
Just takes me off screen. I see
Yeah,
how
I
it
just
is.
ripped you off. I just ripped you off the screen.
Yeah.
How does that
is
look for the case?
fantastic.
Really?
Yes.
Oh,
It is-
this zipper thing is hard, man.
It is just barely dark enough. Like,
What do you mean, her?
No. The zipping him into a suitcase. It is just dark enough to be hilarious. Like, people in true crime love dark humor, and this is just enough that it is subtle enough that it's like he's being zipped into a suitcase right now.
And she's standing there watching.
Yeah, exactly. Like, that's fantastic.
Well, people were like, why aren't you using the real suitcase? Well,
yeah, I was listening to that.
I'm like, you know what?
No.
I mean, I looked at it, but I was like, y'all, there's a dead person in that suitcase.
Uh-huh.
I'm not going to use an image, and everybody's using it online. I don't think they thought about it.
Mm-mm.
I am not going to use a suitcase that has a dead person in it on my thumbnail.
Was that the color of the suitcase?
Huh? Yeah.
Wow.
Pretty much. What you doing, son? Matt. What did he come in here and do? Oh, he's hunting for something. So, Lindsay Bay got this. Oh, congratulations, love.
When are we doing another members live?
We were going to do it once a month, but why?
Because I was talking to someone and I realized I was just here hanging out with friends. It wasn't even a live. I was just here talking to friends. It was fantastic. Talking to the chat, talking here.
Really? You enjoyed it?
Oh, I loved it.
Well, we can whenever you want to do we will have the first Saturday of every month unless something's happening and I can't do it. There'll be a scheduled member live. We can do a members live anytime we want. If we have a special topic, if we just want to hang out and just BS together. But that fabric is suitcase fabric.
Yeah. You did really well.
Yeah. But he was little. He was like 5'2", 103 pounds.
All right.
He was little.
Okay, I understand how he was zipped into a suitcase now.
But the other thing is that she said they were playing a childhood game
of hide and go seek, and he zipped himself into the suitcase, right? Isn't that the story we heard?
Mm-hmm. Well, I haven't heard much, honestly. I've worked very hard to try to be as neutral as possible, but that's what I've heard
that's what I've heard.
He got it. It was his idea, and he got in, and she helped him zip himself up.
Oh, okay.
Because you can't zip yourself in from the inside.
Yeah, I think.
And I read the medical report today on one of my lives. Yeah, the ME report.
How was that?
Go watch.
Okay.
Nothing unusual for the situation. There was abrasions and marks and indents, and that would have happened because he was in it for over 11 hours.
Oh.
He did have alcohol at 0.01, nothing major. He did have some alcohol. But
there are reasons for those abrasions.
And you're in that, and this material is, and the thing is that I don't know what the inside of it looks like. He could have been pulling at the lining, trying to get out. And that material is not gentle. And you also have bars in there, and those, even though that's a fabric, you do have a bar or a metal frame to it, and rivets on the inside and things like that. So it doesn't surprise me. There was some, mild contusions and things like that, but all the signs of asphyxiation due to the confinement was definitely there.
I am literally fact checking myself right now because I need to make sure what I'm about to say isn't entirely BS. So,
where would it be entirely BS?
Oh, we'll talk about it.
I am pretty proud of that zipper. I've never, and once again, I did this live, and I've never done this technique where I had the zipper going from the outside to the inside. I actually have 2 layers of that caution tape. One, the zipper's going over it. One, the zipper's going under it. You can't see where I bled them in. Canva is phenomenal. I'm
great.
getting good. What's going on in there? Saw the light flashing. I thought somebody was trying to get my thing attention. So anyway, this is created. I kind of sorta wanted to color her eyes.
You could do a wildly subtle red. Like we are talking wildly subtle. But if it's just like tinted a little bit red, I think that'd be hilarious. Like, here's the thing. This case is so comical. It is just a circus. Like, Karen Reed wasn't funny. This shouldn't be funny, but she is hilarious. She made it funny herself.
Oh, didn't she though?
Like,
didn't she though? I know, baby girl. I know, baby girl. I'm loving on your paw, and you're like, I'm done. I'm done. So let's see if I can.
Okay. So I needed to fact check this because I didn't want to be wrong. I remember somewhere hearing that he was pushed down the stairs in the suitcase. I just remember hearing something about that. That could have been a different case where someone was zipped into a suitcase. Okay, a little too much red on the first eye.
Yeah, I'm going to undo. I need to make the brush bigger.
I think it needs to be smaller, even.
Well, let me see. How do I embiggen and smallen? How do I embiggen? Let me do this
the
one.
line, the 3 lines right under color.
Okay, I'm going to do this one, and I'm going to go transparency.
Ooh, there you go.
That's too much. Weight come down a little bit, and then we're just going to go.
Oh, perfect.
And we're going to come out.
Oh, yes. Okay, I'm turning up the brightness on my monitor real quick. I need to see this.
Do I need to go a little darker?
No, that is perfect. Because here's the thing. First look at it, you don't see it. It is so subtle that if you look at it long enough, you realize it. That is fantastic.
Yeah, I like playing those kind of games with people. I like messing with their minds a little bit. Yeah. So let me embiggen, close it, then open it again. Show screen. Window, tire window, share, put on stage.
Yeah.
Yeah, it's very subtle.
It's so subtle, but you can see it. That's great. I think that is perfect.
Somebody said I should put a hand like he's trying to crawl him out.
I
A little too
don't
hard.
know. I don't know if that would be difficult.
I wouldn't do that. That's a little too much.
That is a little too much.
I'm sure they said she pushed it down the stairs, and she definitely turned him over in the video. Yeah, so all that moving when you're that. I got to be honest. I was a very tiny kid. I was 98 pounds at 5'1", so I was about the same size this person was for buku years. I never got higher than 110 for like till I was almost 30. And I used to get in suitcases and play games and get in tires and I did all kind of crazy stuff. But I didn't have a psychopath that wouldn't let me out. And I didn't actually, we didn't fully zip it. I was always too scared to do that. But I was a contortionist, man. I could bend over backwards, grab my feet, wrap my knees around my head and roll around like a wagon wheel.
Yeah.
I was a gymnast, wow. But I really like this. And I can't remember who suggested the caution tape. I was thinking about it. It needed something.
It did. Absolutely. And that is perfect.
I wanted to find the police line.
Yeah.
But I couldn't.
Think that's perfect.
So, yeah. Oh, that red is just, ooh.
Right? It's creepy.
When you look at it, it's like, ooh.
Uh-huh. Like, it is just barely there, but it's there.
Now, some people were saying in the videos the suitcase looks green, but I found some pictures of online that were taken with better lighting because that kind of shade can turn green or whatever.
Oh yeah,
and it's actually that shade or close to it, not exactly. Me too. I'm 5'2" now and was 98 pounds for years up until my late 50s. Yeah. So, but he was a little person, smaller than her.
Yeah.
How tall are you?
Me?
Honestly?
I'm 5'9" in shoes.
Then we came on and we looked at the Karen Reed. I mean, look, there's a new document on the Karen Reed. There's a new and then we also then looked at the Hannah Gutierrez Reed thing. But I also came on and I spoke about recognizing deception in someone's words and how they talk. And I didn't do that great. I had a headache this morning. But one thing about Higgins is he goes, I. And when someone does that, they're deceiving.
Mm-hmm.
And it is something a lot of times they don't realize they're doing. In the beginning, it was double I, then it went to triple, then it went to quads. And that, I mean, he was so uncomfortable with a lot of what he was talking about. And they also are more uncomfortable because when they start adding information in, not all the time. So if you can sit there and ask somebody a question, they go, yes, and da-da-da-da, yes, and da-da-da-da. That's a pattern of behavior. So that's their baseline. But when he started, it was yes, no, this, that, just clear. But on certain questions, he started pouring information in a way that's a way of them to try to get you to believe what they're saying is true because they're going to give you more information to make it sound more truthful.
Because they don't think it sounds truthful because it's a lie to them.
Right.
When in reality, the way to do it is you explain it just like you would anything else, answer it like anything else. But because you have a hard time seeing that, it's difficult to do. Because you think it sounds weird. And
well, and the thing is that he knew what the state's timeline was. He knew all the state's information, and he's worried that some information may or may not get in. So what he's trying to do is try to drop these little jewels of information
Yep.
because he's not being asked when he thinks he should be asked. And that happens a lot. I was on the stand on another case, not my husband's. And did a run through with the attorney because I, never testified that at that time. And I was trying to, but this and this. He goes, look, answer the question. If it's yes, no, it's yes, no. Don't say another word because what you say can actually end up hurting us. We want to frame it in our timing. We want to unfold this, and we have a manner in which we're going to unfold this information because it builds and the credibility or whatever. And I said, okay. So I get on the stand. I do good with prosecution, I was on the prosecution side. And then the defense lawyer got up there and tried to get me to expand. Well, do you want to expand on that? Do you want to, is there anything I don't, nope.
Nice.
Mm-mm. Ask me a question, I'll give you the answer, but I was taught properly. But a lot of times though, when you're lying, you forget that stuff and you just are. But I believes, and I think it could possibly have been, and then he turns around and the next question or so and gives you the exact information, like the date or time. So he's uncomfortable with whatever that question, date, and time is. So he's not wanting to reveal. So after I sat there and just broke him apart the other day and listened to him in the car. And I was just taking all these mental notes. And I'm like, this son of a bitch did it or knows who did. And it wasn't Karen Reed. Because anytime he talked about O'Keefe or Karen, he struggled. But, and something else was he talked about, he listed his friends. And then he took the Brian Albert, and elevated him as a friendship. So-and-so works with me. We hang out every once in a while. But Brian, we there's that and he elevated that friendship. Well, what did he do? What did Brian do? Or what did you do to elevate that friendship so fast? There was just a lot of times you listen to what's not said. And there were times he would drop words when you were talking about situations that were uncomfortable because you could see it's uncomfortable, but you can hear the words. He would drop simple words, or he would talk in them, they, and not we, us. He would remove himself from it, even though he's in it.
Yeah. I believe he was directly involved. My theory of it is he and Brian Albert were downstairs. John O'Keefe was downstairs, and they got in a fight. The dog bit him. He fell back. He smacked his head. He dead.
I don't believe his head was smacked.
I think it was. Not on his own.
No, I think they were in a fight. The dog was on him, and somebody took a barbell or something and hit him over the head. Because if you look at I have a picture of the cut.
Yeah.
When you fall back on something, it's more of an indent and an upward tear because your head is sliding. This, if you're hit and the head, something's coming from above to below, the skin is going to tear downward. Think about that. If you fall and hit your head, you're going to slide like this, right? So you're going to hit and then this.
Oh.
You don't hit and slide up. You hit and your body does this thing. It's going to be on a lot of scenes. If you are hit from above, that skin is going to do this. It's going to be this direction. So any and all abrasions are going to come in the direction of the hit. If you're hit from above, they're going to go down. If you're hit from below and you do this, they're going to go up. Let me see if I have that. I may have that picture. I want to look at it again. It's been a hot minute. But the whole thing is that I believe that he was hit actually with an item in the middle of the fight when the dog and them were all going after it, and he went down, went unconscious, and then they carried him outside.
Yep.
And there you go.
And no one saw him because he wasn't there.
Not at that time.
Not until when that black car was in front of that house.
I know I thought I had it. Let me view these bigger, extra large icons. Because I want to view, because I have pictures of the weight room and everything. I got pictures of the inside of the house. Let me look at this. Open. Yep, it does. Okay, guys, if you cannot handle,
One moment.
I'm gonna try and crop this down. Let me do a fake crop on this so you don't get the head.
And you give me just a second so I can do a content warning.
So you can what?
Do a content warning.
Yeah, because I'm going edit photo, crop. I'm going to crop it because I'm not going to show the face. This is just a cut in the back of the head, guys. Okay. So present, share screen. And here we go.
Okay. Yeah.
See how the indent and this is, it looks
I have one way. One.
But do you see what I mean?
No, 100%.
That is from an upper because it pushes in on the skin and then the skin's pulled down and the abrasions. So this is, to me personally, I'm gonna go ahead and pull it down.
I see one way. One.
Outside of my way?
Yes.
Okay.
There was a brick fireplace. I believe there was a fireplace.
But
I think
if he fell, it would all come a different direction.
Sort of. If he fell just right to the corner of the brick.
That's true.
Right on the edge of the brick, it would do that.
Where was that, though? That was not in the basement. That was in the upper house.
I thought that was in the basement.
Let me look. I have pictures of the basement.
Yeah. Like, from my remembering, there was something that he could have hit his head on with a sharp corner.
I'm going to pull up the floor plan as well. I think the floor plan will show it better than the actual picture because the picture is only from one angle. I don't want Canva to open this. Open. Oh, I don't want Canva to open this. Dagnabbit. Open with. We'll just see if Photoshop will open it. I haven't paid my subscription. I get really tired of paying the subscriptions, and now I use Canva so freaking much.
Yep.
I don't use Photoshop that well. Let's see if I can embiggen. Exercise room does not have a fireplace.
So was it the exercise room they were in?
Well, the theory is this. Let me show the screen because I've got the entire floor plan. The theory is this, and that is that the let me get this up here. I wish it would just jump to the one I prefer, which is the bigger of us and big in us. So let me move this out of my way so I can examine this a little better and help y'all. Oh, no, I'm going to do that to make it look better. This right here, upper one, is the main floor. And see here, this is the fireplace in the study and the fireplace in the living room. Now, don't forget, the police were on this floor. When they broke people off, one went in the study, one went in the living room, one was in the kitchen. So there was no blood anywhere. Okay? And down here's the exercise. No fireplace, which it would be right here. No fireplace, because this is a systems room. nothing down here.
Yeah.
The second story does not have a fireplace. I mean, the third story, the master bedroom and all that, no fireplace.
Okay, so if we ignore fireplace, if it's an exercise room, there would probably be exercise equipment.
Right. And that's what I'm saying.
So,
If anything that
honestly,
happened downstairs,
any right angle, if he fell at the right place,
Mhm.
would do that.
I wouldn't
Like,
disagree.
that is one hell of a injury to get while falling, like you're saying. It is.
Yeah.
There are not a lot of ways that is physically possible. But
I don't think that's a fall, honestly. I
Okay.
really believe that is a hit because
so do you
normally
think he
falls,
was punched in the face?
honestly, normally falls are not a perfectly straight. Usually they're on an angle.
Yeah.
And where that was hit, I mean, the fact that, and if it was a corner, they would describe the wedge shot into the skull where the
Mhm.
damage was, and they didn't. Let me show this. They did not, and I could be wrong, but that's okay. We're just discussing and cussing, as my grandma said. So here's the weight room.
Oh,
This is after they redid the flooring and
yeah.
repainted.
Okay.
So they had
And I have a feeling they would have gotten
weight.
rid of
Look
the
at these big,
equipment.
look at the big dumbbells right there.
Mhm.
Okay, that is something that can cause that kind of, even a 5-10 pounder can cause, with the force of a strong man, can cause that.
Here's the thing. I
Uh,
don't believe.
It's possible it's an edge of a step, but once again, you hit and he would come upward.
Yeah. Yeah.
You would fall back and come like this. You
Yeah.
would rip the skin forward, and it wasn't.
Yeah, but if there's that sharp right angle and you
Mhm.
fall backwards right onto it,
It's
and
possible.
that's it, and you just like slump forward. So my thought is, I don't think it was on purpose. I don't think it was intentional, and I think if they hit him over the head, it was intentional.
Not necessarily. I think that if they're all brawling and he's giving it back, or he's trying to, and say one of the women came down to see what the hell was going on and they were brawling and she picked up, like Jen, one of the weights and whacked him on the head.
Yeah.
I don't know. I'm not saying they intended to kill him. Okay. But in order to stop the fight, if he's facing the fighters and they, getting in between, it's not possible. You know how many times in a bar people break a glass over someone's head to stop the fight?
I would agree if it was a
They don't
one-on-one
intend,
fight.
but they
That was
don't
a
intend.
2-on-1 with a dog.
The dog could have come in at the end when he not. What I mean at the end is after he fell to the ground, the dog could have joined in.
I don't think so.
I don't
Because
think
they were hesitation marks, and the way those striations were, it looked like he was fighting the dog's grip.
Mhm.
So he was trying to pull away. I think, and this is my theory, they're in a fight, and Brian Albert attacks him, or John O'Keefe attacks.
We're good. Matt, quit eating all my candy. Quit stealing the candy.
Taking a Hershey's Kiss.
You can take whatever you want. I'm just kidding you, babe.
And I think that one way the brawl started, it was Brian Higgins and Brian Albert on John O'Keefe. And that dog, I think, jumped in. And I don't think Brian Albert and Brian Higgins intended the dog to jump in.
No, I don't either. And I think it was over Karen Reed.
Oh, yeah, no, I think it was. And I think that the dog, between the dog and everything going on, he tripped backwards, smacked his head on a piece of exercise equipment, and he's dead. And now they have no idea what the fuck to do, because they killed him, basically.
All right. Did you hear me? Whoa. I had my music ears in. Did you hear me when I talked about this investigator guy who was doing his own investigation? And what I don't like about the hearing aids is there's an echo. And he got someone contacted him, and he is a very close friend of the Alberts. And he sat down and told him what Albert told him when he was drunk one night.
Okay. Continue.
Give me a second. I gotta get something. It's in my hiding spot. This is all Karen Reed. I took good notes.
Mm-hmm.
Okay. Let me see if I can find it. I know it's at the end. So, what this is a gentleman. I love my son, but he never shuts my door. And all I hear is his mouth.
Yes.
It's not necessarily clean. Because they're sitting here playing a game. Let me see. I may put
Yes,
it
Cindy.
in. I took it out. What?
I agree, Cindy. They covered it up. And I think that's all that needed to happen. Like,
Yeah.
I don't care how he died. They covered it up. He died in that house, in that basement. And they covered it up.
Yep.
I mean, hell, it could have, if we look at it in the light most favorable to those two, the dog started biting him. There was no altercation, and he still fell backwards.
Yep.
Like, I believe that there could have been no altercation whatsoever. It was just the dog and Brian O'Keefe. Like,
so
here's the thing.
I may not be able to put my hands on it that quickly, but I can tell you what it said. It was, it was good.
Yes, do tell.
Trial date 28. Oh, I found it. Okay. Let me get to that part. There's a lot of stuff.
Yeah, I'm sure there was a lot of stuff in that.
They
go
through this very well, but this is his. Okay, so I think it's going to be on this page. Well, first of all, let's go to the plow driver. This is interesting, and it didn't come out in court. It was one of their motions to keep it up. So, okay, here it is.
Yeah.
Does anybody remember the name of Steve Stanley? No. Do you know why?
Why?
They kept him out.
Really?
Steve Stanley was not there. But someone in the house told him, someone who was in the house, who lived in the house, told him. And he was extremely good friends with Brian Albert. The department sheriff together in Boston and Gulf War, etc.
Mm.
When asked to sign an affidavit, he freaked out and said no, he would not get involved. They tried to subpoena, and it was squashed.
Okay.
But on a night of drinking, a certain individual who lives in the house, who owns the house, who he's friends with, said, okay, now this is the cover up. Basement
Yeah.
gets dried up, water break. They had a water break. In the basement, they dug up the cement to get to the pipes and all that.
Yeah.
The house sold for $50,000 less than the appraisal market price.
Oh, really?
Yep. Now, the plow driver, there were the 3 plow drivers.
Oh, yeah. I
And the
remember
plow
that one.
driver at 4:30 heard on the radio that somebody called in pedestrian down Fairview Road.
What?
Plow driver assumed that somebody else, i.e. dispatch, which is their job to call it in.
Yeah.
You're messing with your screen behind you. Be careful. So he didn't know it, but no one had called the cops. Tow truck driver 2. Okay. He gets back to the barn and goes to his boss and says, hey, what happened to the pedestrian down in the snow on Fairview? And the boss tells him, if you ever tell that story to anyone again, you'll never have a job with me or anywhere else in town.
All righty.
Listen, the boss is a Canton PD officer.
Yeah, of course it is. Of course he is. I expected nothing less. I would have. It is either it was literally an Albert, or he was a police officer. Those were the only two
Brian
things in
A.
my mind.
Brian Albert has beaten several Boston cops off duty while drinking. He said, if I go down, you're going to go down with me.
Okay.
Between 1 a.m. and 6, a lot of calls were made. Okay. To FBI and other people. Okay, let me get down to this guy's testimony. The other thing was, and I'll tell you this story. Brian Higgins was, he actually signed a proffer agreement. And I don't think that was actually brought up in court with the FBI. An assistant U.S. attorney gave him a proffer, and they told him the assistant DA and the DA told him to destroy all phones, tear up the SIM cards by Michael Morrison, and he told Brian Albert to do the same thing. The DA said, when questioned, and this is what Albert had told this guy, it's okay. If anything happens, the first assistant will go get in trouble, not him. Because technically, he didn't tell them directly. He told them through the first assistant. The first assistant, is the one that told them to do it per Michael Morris's orders. And has nothing, and he isn't, that. So here's the story. That as soon as they got in the house, there was a scuffle over Karen Reed.
Yeah.
And it quickly went downstairs. It was a verbal altercation and quickly went downstairs. And they're in a fight. And it's all of the men.
Mhm.
Now, I don't know. There was more than just the 3 men down there. And Sensei, someone open the door. Of course, my dog is going to be out there barking. Come on, look at that. Come on. You need to stay in here and quit going in and out, my dear. I didn't know you left. So anyway, they're in a fight. He gets hit overhead with the barbell.
Yeah.
Goes down. The dog was in the midst of the fight. Okay. Yep. So that was a part of it. But then he's laying there for 20 minutes unconscious. They leave the room. Then one of them goes downstairs to check on him. And he was convulsing, foaming at the mouth, and vomiting.
Oh, I remember this now.
That's a head injury.
Uh-huh.
They picked him up and there was blood everywhere. Head wound, bleeds.
Uh-huh. Badly. I've had one.
And yeah. And so, oh my God, you guys, I have ADHD killing me. So then they take him out that upper storm door around and they pull up the truck to hide them, lay him in just in case someone goes by. It looks like they're picking somebody up. The shoe fell off while they were moving him.
Mm-hmm.
And they planted the glass.
Yeah.
Apparently, that is what Albert and this guy had talked about when he was drunk off his ass at that party. Remember that party everybody went to?
Yeah.
So there you go. That's what this guy said that this other guy had said to him, directly to him. It wasn't through other people. This is the story that was told to him. It's very plausible. Now, I'm always going to leave room for a lot of possibly, most likely didn't happen. I'm going to leave room for that. But to me, that's the most plausible thing I think I have heard. Unbelievable, but I believe that. Yeah.
Unbelievable, but I believe that.
Huh?
Unbelievable, but I believe that. That is this entire trial.
He didn't die in the house. So when the police show up, who is not talked to or seen but in the house?
Wait, he didn't die in the house?
No. He's foaming at the mouth, convulsing, like having a seizure-like activity,
Yeah.
and vomiting, and they pick him up and carry him. He died. You remember, he was barely there when they got there. Remember when they got there? They had started CPR and all that, but he didn't die in the house. He died out there. If that head injury had happened and they called 911 right then and there, he would probably be alive today.
Uh-huh.
Because what really ultimately killed him was the bleeding on the brain.
Yeah.
And then the cold.
Mm-hmm.
But the cold would actually help the swelling on the brain.
Yeah.
So it took him longer to die.
But all of that was hearsay. Literally every piece of it.
That's why it couldn't come in.
I know.
But do I believe that? That is the most plausible. That is the most plausible story. Yeah. If you really just take all the bullshit out of the way. Who cares how many times Jen looked out the window? Do you know why she says she was looking out the window? Because they dumped his body and she wanted to make sure it didn't get up and walk away.
Uh-huh.
House long to die in the snow. Jennifer McCabe made search at 2:30 or earlier. Yep.
Yeah. Their technical expert did do quite a bit for me, and I do understand how that search could have already been there. I see how it could based on his testimony. I don't know if that testimony was accurate.
See, I agree with you. I understand how that works. But
It makes no sense otherwise.
the time that she said that she was doing that search
Mhm.
was at 6 something in the morning, right?
Mhm.
What was she doing at 6:30 in the morning?
Sleeping.
She went into her sister's house, got blankets, and talked to them. She was with police and other people around.
And no one saw it.
Now, I would have asked the Alberts, did you see her on her cell phone in your house?
Mm-hmm.
Was she texting? Was she? And they said, oh, no, I would. See, that was a question I would have asked.
They wouldn't have answered it, truthfully.
Well, but if they don't realize you're going there, they would. And my other thing is, where's the dog? The dog left with the daughter because she was the last to leave, and nobody saw the dog after that. And I tell you, if that dog would attack in the middle of a fight, then her running upstairs screaming batshit crazy, if that's what she did, and busting into a bedroom, you know damn well that dog's going to cut unloose.
Yep.
Yeah, and she cut through the backyard on the police dash cam to avoid.
No.
Yeah, I mean, it's like.
See, I didn't know these things. Like,
No,
I
Melanie Lewis,
listened to it.
welcome. Welcome. No, he got the fight happened downstairs. The physical altercation of the fight, I believe, happened downstairs from what this guy said. And the fact that, who's the son?
Colin.
The son, Colin. When the police came in to talk to everybody and inform them of what's going on, nobody talked about Colin. Nobody saw him. Nobody saw the son. Or was it Brian Jr.?
I don't know.
What's the name of the son?
Brian
Anyway,
Jr. and Colin are.
Yeah, the son, Jr.
Okay.
They never saw him. The police said he wasn't there. They didn't see him. But the parents said he was in the house. Upstairs. He said he was upstairs. You live 25 minutes away? Ooh. You should have gone to the trial, girlfriend. So they live in this house with their son. He's down in that basement and nobody investigated the house.
No.
Nothing looked out of place. Well, did you look? I mean, there's 3 stories in
They
this
had
home.
no probable cause.
Bullshit. Dead body in the yard with a glass. That glass alone is enough probable cause to go in the kitchen and see if it matched anything. Or look on the wet bar. These people were drinkers.
Yeah. Really? I didn't get that from all the underage drinking.
No shit.
Like, uh-huh.
There was so much underage drinking. That wasn't even funny.
Mm-mm.
And none of them got charged. I'm
Oh,
like,
yeah.
what?
All the drunk
You guys
driving.
aren't charged. They
Like,
could still charge him for that. They could have charged them.
mm-hmm. Like,
And
yeah,
what
all the
about
DUIs.
police
All the
officers driving
DUIs
home
in the,
drunk?
all the DUIs in the police cruisers.
What'd you say?
All the DUIs in the police cruisers. They admitted on the stand that they weren't allowed to drunk drive in their cruisers. I love that they made that distinction. Yeah, we're not allowed to drink and drive in our cruisers.
If I was a police chief and I found out that any of my people were drinking and driving, even if they weren't the murderers, but they admitted they'd been drinking and driving that night, honey, we'd be having a serious conversation.
I think that conversation would involve surrendering your gun and badge because you literally committed a crime that you're supposed to pull people over for.
And you're enabling a minor and providing alcohol to minors that were not all your children.
Oh yeah, that part. Crazy that.
and you're home and you're condoning it. I'm just, y'all. And then in the Sallyport,
That was the dumbest. It was flipped. It was the entire video was just
I
edited.
get that. I get that. As a photographer who's dealt with things like that, that didn't piss me off near
No,
as much.
the
I know.
timestamp was backwards.
I know. I understand what you're saying. And I agree. That was stupid. But what pissed me off was worse than collecting blood in a Solo cup and putting it in a gas station bag is then you put it on a dirty floor with a mat that's full of grass and rocks and dirt and debris within a foot of the other evidence, which is a freaking vehicle. And you were handling it with gloves. And then there's blood somewhere that you said you found because you were transferring.
And it doesn't matter where the blood came from or what spot it came from. We just put all the blood into all the containers. We just
Well,
mixed it all.
first of all, that blood is not viable evidence because it was in the snow.
No.
They were just collecting something to make look like where they were doing something. I would have loved to have been the state police sitting there looking at that going, and the FBI going, what the? Where is it? Where is it? Where is it? What's the? Was that? I was like,
Yeah.
I have a dear friend who she's retired PD, that she still works sort of in the law field still. And she was up north in that area. And she was in evidence collecting. And yes, she went from being a tech to a supervisor and all that, and in charge of the evidence locker. So she had the gamut.
Mhm.
She did all of it. And I told her this and the leaf blower, and she all lost it.
I told my grandpa, who was a police officer many years ago, he about lost his mind. Like, these are the kind of cops that give cops a bad name.
Well, but the thing is, if you're going to sit, you're good sensei. If you're going to sit here and frame somebody, and you're a cop, you damn well better do a better job than this. I'm just saying.
Right? This was so much.
All the technology at the palm of your hand to frame somebody, and you were doing this bad of a job. I'm like, what the hell? My husband is.
Movies do it better.
Oh, look at this, Cindy. My husband is an evidence cop and about fell over. Would he like to? Would he like to come on and let me talk to him? I'd love to have him come on. Let's have a conversation. Would he come on the show?
How
A lot of times they won't because their
crazy
department
everything is.
won't put up with it.
Yeah.
But I'm like, what the hell? No gloves. And what
What
if
are
you're
gloves?
about finding all of that glass under all that snow
Okay.
up to 3 weeks later? Do you know what I believe?
What do you believe?
Do you know what I it's only $180 something for the new headlight. I believe they bought the headlight and busted it up and scattered it.
Mm-hmm.
No, not technically. I thought about buying
Here's
the
the other
headlight.
thing.
I
Do they-
thought about buying the headlight and mounting it on a very sturdy fence post and ramming my elbow into it and see what happened. But I love my elbow too much.
Here's something I want to know. Were there any other models just like her car?
Oh,
in
yes, I
police
do.
impound?
I do want to talk to him, Cindy. Do you know what? My mother has the same car.
So here's the thing.
And I went up to that car and I went with her permission.
Okay, but think about this. If they had the same make and model of her car in police impound in whatever their auction sites are, boom, untraceable. No one bought the headlight, and you just took it from another crime car.
Now, the crack in the headlight, once they put all the pieces back together, looks like the glow and all that comes through when she drove away from the home after tapping into O'Keefe's car. When you see the light peeking out pattern when you blow it up, it matches it once all the pieces are put together. I have the video and everything to show it.
And don't you love when the guy didn't pull out all the pieces of evidence, all the glass?
Yes, because there were more in the bag than that was recorded.
Uh-huh.
If he's smart, he goes, "Oh, they broke. Well, it was a bigger piece, but it fell apart."
Then I would have asked him to put them back together and show me.
I would have too. I would have loved that. I would have loved it. Cindy, I'm not BSing. I want to talk to you. I want to hear what he has to say about these idiots. I want to hear him tell us how they should have handled this. But I don't think the blood in the snow is collectible evidence because the snow is contaminated. People think snow is clean. It's dirty as hell.
Oh, yeah, no.
How do you think snow forms on dirt and dust particles in the air?
I live in Utah. I can tell you just how filthy snow is. We don't, in the mountains, we have fantastic snow. It's beautiful. It's some of the best snow. Okay. If you ever heard about the inversion in Utah, the entire valley gets smog essentially over the top of it because of.
What is not, Cindy? Sorry, Cindy. What is not? What's not? Is that you dinging or is it me?
That's you. Sneaky
I don't know
sight.
what's dinging.
Yes, it is.
Oh.
Yes, he is. Yep. Same grandpa.
Yeah. Oh, by the way, the parents of Aaron Greenberg, teacher who was found stabbed 10 times in the head, not including the rest of the body, won the right to challenge the ruling for the chance to change her case of death to homicide, according to the reports.
Interesting.
Oh, all right, good. I'm good. I'm right then. Blood in the snow has too many variables. Cindy, get him to talk to us, please.
Yo, Cindy, if you're in Discord, we can
He
just
doesn't.
throw you the link.
And we don't have to have a face. We can just do voice.
Mhm.
I can give you my phone. You can get the link. Actually, I'll just do a phone. You don't have to. You don't have to do a face. But I'm like, this is crap. Oh, well, that's okay, Andrea. But I mean, there was a lot of things that were too many. And using 2 Q-tips on the entire shirt. Yeah, he must be interesting and good grandpa.
Oh, I love
He must be cool as hell.
He is.
But let's talk about the shirt. See, Cindy, RN, I need to talk to your husband. My humble opinion is that you would use a Q-tip per bite or tear. Maybe 2 per one. Oh, there's a book about him?
He wrote it himself. And
Oh, I
you
got
can
it.
do it online. So
Hold on, Brad. Cindy, would he talk to me privately? And I won't use a name? But I understand when you're involved in that kind of stuff. I get it. I'll stop asking. Okay, go ahead, Braxton.
Yeah. So there's this thing called Storyworth, where like every 2 weeks or something, you get a prompt, and it will be a book at the end. Each one's a chapter. So you write about one of the prompts, and by the end of it, you have a full book. So, yeah. But you
Lindsay.
can see just how thick that book is for
Yeah.
his life story.
That's awesome.
Yeah.
Lindsay, I appreciate you. Thank you so much for joining. And please share this. If you, I know you're already subscribed, you got your membership, but please share us with your friends and family. We appreciate it. Thank you so much for hopping on. Hopefully, we'll see you again real soon.
Yeah.
Get a good night's sleep, love. Night night. But it is one of those things about the evidence collecting in this that just, there's a lot of bad things, but two Q-tips for an entire shirt.
Yeah. I just lose my mind.
And doesn't it, if you use 2 per one section, and say you did 8 groups, and number 4 comes up with an alternate DNA, you know exactly where it was on the shirt, and you can isolate it more if it's isolatable. But if you take the 2 and rub it all over the shirt, does that not affect the quality and does it not recontaminate the DNA and all that by adding all of this other stuff to it? Night, sneaky.
One more time.
Okay, when you take 2 Q-tips,
yeah,
and you rub it all over a shirt, and it comes up with a DNA, or you take. Okay, let me back it up.
No, I understand.
If you take 8 sets, there are 8 holes, for example, and there are 2 Q-tips per hole, and you rub 2 on this one, save it, 2 on that one, and you mark them 1 through 8, or A through whatever.
Mm-hmm.
And the 4th one comes up with the DNA. Okay? Or you go with 2 Q-tips all over 8 spots. If DNA was found, would it not be diluted, altered, or contaminated to the point that if there was any hope of extracting it, you just destroyed that hope? It's not right, guys. I can tell you that as a sane nurse for years.
Yeah.
Again, it wasn't reprimanded. Oh my God. So I'm right, Cindy, isn't I? Aren't I? Or am I?
No, you're 100% correct.
But if you use the 2 Q-tips on the one spot and there was DNA, you're going to have a stronger representation because it's not contaminated by everything else. And you potentially could possibly get more information. And nobody's reprimanded? Huh?
Imagine that. Only in Canton.
I hate to say it, but it's a lot more than just Canton.
Oh, I know. It's lots of small towns all across the United States.
Even big towns are sloppy.
Yep.
You can use 1 tip per sample, dry completely before placing the cotton in and sealing. Yeah, exactly. And I'm not in evidence. Now,
no.
I've been around the medical field, so I understand sterilization. I understand isolation. What, Braxton?
Here's the thing. These investigators, these scientists, everyone involved with this case has destroyed their career. If they ever testify in another trial, this comes back to bite them. It's, well, didn't you testify about this in this trial? And didn't you... Didn't you use 2 swabs on the entire thing? Like, I'm sure a lawyer could figure out how to phrase it, how to bring it
Well,
in.
the lawyer would have a field day.
Yeah, with
You know what,
every
and this
single
is
one of
true.
these.
Now, the thing real quick about we'll go back to evidence. You never place a wet tip in the carton. It will, yes, yes, yes. And I'll come back to this, Melody. Give me a minute. The glass that was in the bag, they never swabbed it for the contents.
What? All right. I want to say this. This
I'm not-
was the death
not
of a
kidding.
police officer. This was a police officer, and they did jack shit.
Yeah, because they knew a cop had already been involved in the murder.
I know. Like, but can you imagine this happening?
Cindy's right. They will re-wet the tips. And the glass at the bar and the glass at home, one said it was tall, one said it was short. Yeah, no. So this is true. I can't wrap my head around why this is still going on. I feel bad for the O'Keefes too. Some justice. Well, hi, baby girl. Are you needing some loving? Come on. You want to say hi? Come on. Come here. Oh, mwah. I got sugar. I got sugar. I got sugar. Oh. So I feel bad for the O'Keefes, but on one hand, the O'Keefes have been so lied to and blindsided and manipulated and brainwashed. But Mr. O'Keefe, he liked Karen, and he still does.
I don't think they think she did it.
He doesn't. Mama's a different story. She's tight with the Alberts and the McCabe's. She had them sitting with her during the verdict reading. The glasses didn't match. You are right. They didn't. And in the video, it shows they said that O'Keefe left with a glass out of the bar. In the video, he was drinking a beer.
Yeah.
When he walked out, he didn't have a glass in his hand. He had a beer bottle in his hand. I saw the video and I started screaming it on the live. Yeah, it was about the cop dying. It was about the officer's house that it happened at.
Right.
Yep.
Which is
Yeah.
sickening, to be honest.
And I'm not an investigator or police officer. I'm just seeing this in court. You wouldn't want me on this trial.
I don't
And
think
I would be
anyone
going.
would want me on
I'd
it.
hang it if they were all four guilty. I'd be the one hanging it.
Like,
What are you doing?
like I've said this before. I would be the one that hangs it. Like, I would be the one who hangs the jury. And as much as I hate to watch hung juries be called,
Yep.
I would be the one to hang it. I wouldn't just follow. So I understand it.
I am beyond frustrated at the fact that this is still going on. Now, I understand it's stated in the affidavit that was sent in by Karen Reed's attorney that the jury was hung on the second count. Nobody believed she meant to maliciously did it or even knew she did it, but they were hung on the alcohol and the drunk driving. However, I don't believe those alcohol lab reports were accurate either. She would be so drunk, y'all. on that scene that she would not be standing up straight, and they would smell it on her. Oh, yeah. They would smell the alcohol on her. They would have done the test. What is that? Pokemon?
No, that'd be much, much cheaper.
I have no idea what it is.
This is Magic the Gathering.
Oh, wow.
I'm scanning in all my cards so I know what I have and knowing the value. Currently, I have scanned in around $3,500 worth of cards.
Yay. How much did you spend for those cards?
Roughly the same.
That's okay. It's your hobby.
I love it.
So they never got an expert as to her disease. To me, it doesn't matter. But what got me was the fact that alcohol report, Miss RN, am I not true? Somebody with a 2 point or whatever it was astronomically high. They would be smelling it. If you've ever worked in an ER or been in an ER and someone has levels like that and you're close to them, oh my God, it reeks.
Well, it's literally seeping from your pores.
There was no altered behavior other than hysterics.
Like, you sweat out alcohol. That's why you smell so badly of alcohol. It comes back out through your skin. You reek because you actually can't get rid of it.
So for me, that was huge. So I don't believe the report. And the fact that they Section 12'd her and put her in the hospital and did all that kind of crazy crap. And the EMS unit that came in and investigated, when they called the EMT to Section 12 them, they went out and talked to the guy and said, she does not appear to be Section 12. She's hysterical because he's probably dead. She's upset. Yes, she needs, maybe a sedative, but she's not a Section 12. And they said Section 12er. Oh,
Melanie Lewis, yes, it
matters
does.
for the rate of absorption. And vodka smells peeps. Worse than beer to me.
Yeah.
Beer's bad. Vodka?
If I want to get drunk, I drink vodka. If I want to enjoy it, I drink whiskey.
Say that again.
If I want to get drunk, I drink vodka. If I want to enjoy it, I drink whiskey.
Moonshine.
Oh, God.
I'm a Tennessee. I'm born in Tennessee, dude.
No, I'm not saying.
Have you tried the smoky moonshine that's flavored with cherries? Oh, they have pineapple soaked in moonshine, cherry soaked in moonshine. Now that's good. But here's the thing. I can only have this much. And that's maybe once a year. But my thing is, once you get through all that, and she was Section 12, which to me was just oh, no, you don't.
Basil Hayden. Kentucky bourbon.
I got a TT anyway. Hold it down.
I've been saving that for when I got my job. Now I just need a time to open it.
Oh, darn it. I don't have any here, guys. I guess we threw it away because it went bad because it had fruit in it. I was looking for my Smoky Mountain whiskey. Now that moonshine I wouldn't touch. I get the professionally made in a distillery.
Yeah.
You can go down to, what was it, Pigeon Forge in that area of Tennessee, and they have their shops, and you go in and you pay like, I don't know, $20, and they get these little communion cups, and they line them up with all the different flavors from the weakest to the strongest. Girl, nope. Let's see. That alcohol was not being stored.
That is very fair. I don't know. I think if she was actually that drunk, it would have been obvious. Then again, tell me, do you think these officers could even tell if someone was drunk?
Well, these were not the same officers who was drinking.
I don't care. They're Canton PD.
I think that those drinks that were on her tab and all that were not just for her.
No, obviously not.
And she was not too drunk, and her backing out and hitting the taillight. I'm sure that I have a friend that has a driveway that you have to back up and kind of like she did, and there's a wall, and then you have to turn out, and it would be so easy for me to clip that wall in bad weather, especially. What did you know, Ronnie? In the least smelly of spirits, it's the least of the smelliest of spirits. However, vodka can still be smelled if you're trying hard enough.
Yeah.
What is the
extrapolated?
I don't know enough about that to answer that question. Go for it, Brax.
What was that? I don't know. It's a great question.
Was that on the toxicology report? Is that what she's talking about?
I would assume.
They said it was a 2-point something. There was a high number like that.
0.2?
If I know what week it was, I could pull it up. But unfortunately, I got to know what week it was.
0.2, and you aren't functioning.
No, 2 point.
How could it be 2 point?
Don't get me lying. Google it. They'll tell you what her alcohol level was. I bet you Google it and it'll pop right up.
But would it be correct?
Let's see. Are you Googling? Googling?
I can't get to my keyboard.
Why not?
Because I have cards covering it.
Karen Reed had the blood alcohol content of 93 milligrams per deciliter. The legal BAC limit in Massachusetts is 0.08. Based on the police report, her peak blood alcohol level would have been 1.35% and 0.292.
0.292? One, that's a wild range. Like 0.08 is the legal driving limit. 0.13 is not all that far off. I think you could still, you could still drive.
Listen to this. BAC levels, okay? 0.15 to 0.30. In this percent range, you may experience confusion, vomiting, and drowsiness. And 0.3 to 0.4, the percentage range, you'll likely have poisoning.
Yeah.
She was on the verge of poisoning.
If that's correct, yeah, I don't think it is.
Correct. And they said this was drawn hours later.
Yeah, but that range of error is insane. Like,
But even
it
if you
was
take the
between
lesser,
1.3 and 0.13.
even if you take the lesser,
0.13 is not that bad.
oh, look, good, Ronnie. He calculated her blood alcohol at 9 a.m. The time of the blood test was between 0.078 and 0.83. But because of her body weight and everything else, they believe the maximum level was between 1.35 and 0.292.
Do they? Do they know the? I don't know.
And then she's got all that disease. She couldn't drink that much liquor with that disease. She has Crohn's, right? That would go right through her so fast. She'd be so sick.
Yeah, and so it
He's
wouldn't have had to.
He's an expert for her disease and the rate of absorption and the BAC opposite. Yeah, exactly. But see, I think she would be profusely sick because
No, yeah.
I have a friend who has Crohn's and she's had the colostomy bag and then the reversal, just like Karen Reed. And she goes, I can't drink anything but maybe a fourth a glass of wine, and I'm sick as a dog, and I'm in the bathroom. And they all said she did not appear to be under the influence.
Mm-hmm.
They said, well, she could have had a drink when she got home.
Exactly.
Well, she didn't have a colostomy bag anymore. It's been reversed. But
I don't think it was reversed.
I thought it was reversed.
I believe she had it during the trial. To my knowledge, she had it during the trial. Like, I could be wrong.
I could have swore they said it was reversed. And the unprofessional comments, oh my God, that in and of itself is horrible. Oh, I don't have an explanation other than they're regrettable. And it's something I'm not proud of. The laugh that I used to. Oh, please. Um, 44. I'm trying to see if it says. I thought it had been reversed, but it may not have been. But even if it was, she's still not normal and the same, and it still would be very, very difficult.
Yeah, no. And like everyone's saying, with the colostomy bag, it would have gone straight through her. Like, doesn't alcohol have to go through your liver?
Yep. Well, and here's the thing. People with gastric sleeves for weight loss surgery, you get plastered faster than someone without the surgery. Yeah. And it's the same kind of effect that Crohn's has a lot of times when it comes to alcohol. Yeah, even Ronnie said she remembers hearing something about a reversal.
All right.
No, I think she had recently had the reversal. I mean, it hadn't been too long. Boy, I'd hate to be in prison with a colostomy.
Yeah.
Because you don't get good medical. Not at all. But are you hearing my son?
Ever so slightly, yeah.
I have the door open because the dog is sleeping laying on my right foot. Aunt has Crohn's and has a bag forever. She was also a newly retired nurse and said that Karen could not have been that drunk. Yep.
I believe it.
Yep. Nope.
Like, I don't believe that was her BAC. I can believe 1 point. I can see 0.13. I can see that. I can see 0.15 at max. But she was driving. Even if you're a really good drunk driver, in snow, really? If you were
Sneaky
that
side,
fast-
we've been on for almost 4 hours. You can swear. You haven't heard me swearing? I had to rewrite the comment 3 times before I could not swear. How awful that treatment. I would have been restrained by my lawyers if cops framed me and were, yeah. Well, she's already known about this, so she's already blown her top and done everything. I think she did an amazing, amazing, amazing job maintaining her composure.
Oh, yeah. I
Tired
couldn't have.
man, that's cute, Nick. What?
Nickname. Tired IT man.
Cute nickname. Oh, I'm
Yeah.
sorry. Well, I think, overall she did a good job. But I could not believe that Proctor got on the stand.
They had to. Defense would have called him as an adverse witness, and it would have looked even worse. They had no choice.
This is another good point. Nobody else had their alcohol levels tested. And they drank more than she did.
And
they even went back to the house and kept hot, with the underage kids who were left alone with a 21-year-old in a house full of liquor. And it was like, have a good time.
That's not going to go wrong.
Do you know what? She went to some town and she got out with all the supporters and thanked them and took pictures. And all of her money is gone and her parents' money.
Yeah. Yeah. No.
I would be signing so many cuss words in court under that table. That's one good thing about being deaf and knowing sign language. You can go. And they're going to go, what did you say? Oh, my nose itching. I'm having a hand cramp.
Nice.
There was just so much. I just don't think they needed to drag it out the way they did for 9 weeks. They could have cut that witness list down to a quarter.
Mm-hmm. But they wouldn't have been able to muddy the waters enough for the jury.
Okay, perhaps that's how you would get everything accessibility friendly, huh?
Swearing in court. Signing swear words in court. You'd have to have someone watching that.
That's BITCH.
Yeah.
That's effing BITCH. Or you can go.
Ooh. Isn't this bitch, please?
Bitch, please.
Yeah.
They have to offer interpreters or more education. You have no. I'm a deaf support specialist, advocate, and interpreter, and you have no idea how poor and how horrible the court system is.
Yeah.
We have a place here who hires deaf people because they have a lot of deaf and other disabilities. And one of them had a ticket, a deaf one of the workers, and there was a hearing worker that she'd been teaching some signs, not a whole lot. She could read it better than she could sign it,
Oh.
but she's nowhere near a proficient or interpreter. She freaking goes into court, traffic court with this woman, and the judge said, "Do you have an?" Oh, my friend here, she signed, and the lady said that she would interpret for her. I nearly hit the freaking roof because under the state and federal law, you have to be a certified court interpreter if a judge is in the courtroom. Have you not noticed that when Miss Diane is not watching me in the background or with me, I don't sign court proceedings?
Mm-hmm.
I am not a certified court interpreter. I can do it, but I have a nationally certified / court certified / blah, blah, blah interpreter who is supervising and teaching. I'm getting, as soon as I get my bachelor's degree, I'm going for my national certification. So, and they have to be sworn in. Oh, no, she wasn't even sworn in, Hazel Pretzel. Thank you. Hazelnut Pretzel. No, they didn't swear in, nothing.
Well, there's an appellate issue.
Oh, the judge just let the woman off because it was too difficult. Rolling on.
It was too difficult. Oh, man. That's okay. That's the thing with judges. You're either just going to get it dismissed or they're just going to throw you in jail.
Do you know what is funny? When a cop comes up, I take the hearing aids off. Do you know why? My license plate is a registered license plate, and you have to get it doctored, certified, and everything else for the deaf.
Mm-hmm.
If I speak to a cop, then he's going to assume I can hear him. Even with my hearing aids, I don't hear, especially at night and there are lights in my face. I can't hear enough to communicate and understand. Now, I automatically know here's my license and registration. Put my hands up here. No, I'm not certified in ASL yet. I did not want to take the state certification because I want my national. But under the Americans with Disability Act, I am qualified. Under the ADA, it does not say certified, it says qualified. A lot of states and places want certified. Why? Because you have to go to school, which I did. You have to take the BEI or the certification. And in Texas, it's a couple $100 just to take it.
Mm-hmm.
And only 30 to 40% pass the first time.
Wow.
It is that hard. They have made it so difficult that if you have test anxieties or whatever, it makes it even harder. And I also have to take what's called an English proficiency exam. So if you were French first language and you wanted to be a French to English interpreter, I have to pass the very same test. It is super hard. Yeah. I got an 80 percentile on that. But the thing about that is that I do not feel that it is appropriate for me to have to retake. There are people who take it 5 times before they pass it. That's over $1,000 by all said and done. I'd rather go take the national level, which is more balanced. It's more of a written test. There's a lot more written. You got to know the laws. You got to know the code of ethics. Now, you got to have the history, the acronyms. Do you know that I had over 500 acronyms to memorize when I went to ASL school?
No.
Yeah, it was brutal. It is one of the hardest languages to learn. I got to shut the door. My son's driving me crazy. Sensei, place. Thank you. I'm glad he's having fun, but
yeah,
not enough for me to hear as it is. I live 30 minutes from her state school for the deaf in Oklahoma. They're absolutely wonderful. Yes. Finger red number 1. Finger red number.
Oh, you have to look at the YouTube chat. It's a foam finger that says number 1.
That's where I'm going. I'm popping out popping out the chat. Do you know I haven't done that all day?
Really?
Yeah. Well, didn't have room.
Yeah.
Oh, but hey, the new members Have you seen our custom chats? Our custom emojis? Did you
Nice.
see 'em? Have you seen them, Braxton?
Yes.
Oh.
I love them.
I know. I love my Heidi the Highlander. There she is right there. My Heidi.
Nice.
I created her. Well, sort of. But so ASL is a lot harder than people realize. You don't just learn to interpret words. You got to get deaf culture, deaf history, ADA laws, all the laws, educational laws. You learn all the laws for disabled. It's a lot. People don't realize you don't just learn signs. It's a whole new world. Oh, don't sing the song. I hate it. I know, Highland Lass. Oh, don't you just love the happy poo? The happy poo. My interpreter hates the brown poop emoji, and I'm done with her. I don't like it either. I found a Hershey's Kiss, and it was so cute, but then when it was small, it was like,
Yeah.
Let's see, and you have to perform it right. If you don't, you can. Did I tell you about my story when I learned my first sign in my photography class?
No.
Oh.
Story time.
Yeah, story time. I'm going to do it in a voice. What do you think? Should I do it in voice? Up or down?
Down. Up, it clips out. We need to fix that.
In the year 2001, I decide, after giving birth to my son in 2000, that I should go to school and get a degree. I had been a professional photographer for 15 years. And I thought, well, the easiest thing to do is get a degree in photography. So I signed up for college and I took Photography 101. Now, at this point in time, I ran an entire studio. I did not only the medium format, negatives that thick, 5x7, 8x10, billow. I had a black and white and a color darkroom. I could have taught the class. But I said, oh, it'll be an easy way to break in. So I take the class.
Mm-hmm.
But I had gotten my first set of hearing aids 6 months before. So what did I do? I show up to class, and I sit down, and then this woman comes in and says, where is Miss Blank? My married name was like, Miss Brown. And I'm like, what the hell did I do? I'm your interpreter. And I said, I'm not deaf. I'm hard of hearing and I don't know ASL. And she said,
oh God, please no. Hiring at the end of this semester. It's either this photography class or physics. I tell you what, I'll teach you some ASL or I'll just sit there and flap my hands. I don't care. Please don't tell them you don't need me. I got one semester left and you're it.
and I said, ma'am, I'm going to be bored as hell in this class because I've been doing this for 15 years. So she told me to go that night to Barnes & Noble's. Yeah, when you had to go to the bookstore. And find an ASL book. So I did. And she said, you're going to sign to me what you had for breakfast in the morning. I said, okay. I jolly off. I go to the bookstore. I bought 3 books. I bought a dictionary, about yay thick. I bought 2 other books that had more phrases. And I got to class. And the teacher was taking roll. And she said, "What did you learn? What did you eat?" And I did. What did I roll over? Are you okay, baby? Felt like I rolled over her.
Oh.
I did. So, gotta look. She rolled over, doubled over laughing, literally on the floor, fell off her seat. The teacher said, "Remember the ADA law? Complete and total access? What are you laughing about?" And I didn't know what was wrong. And she couldn't get it out of her mouth for about a minute. Finally, she calmed down. She was crying. She said,
Just told me that a condom.
Now, this, the hand is right here, and there's an arrow, but it didn't tell you to peel the freaking banana. And this is not good morning.
No, it's not.
It's close. Good morning. It's in the middle of the arm. Morning, afternoon, or morning, noon, afternoon, night. So I was so embarrassed. I mean, so embarrassed. And
Okay.
and then my lady in church with me, I used to work on Wednesday nights in the nursery so some of the parents could go to Bible study who worked on Sundays or whatever, taking care of kids. And the lady worked in the room next door and she wanted to learn sign language. So I was teaching her a few words.
Mhm.
And she asked me what hungry was and thirsty because we're teaching the kids. I said, thirsty, hungry. So the next week, do you know how a lot of Baptist churches have meals on on Wednesday nights, and you get there about 5:00, 5:30, everybody lines up, they get there. Well, I'm standing in line and the pastor walks up and he's visiting with us, right? And she goes, "Pastor, she's teaching me sign language." He goes, "Oh, that's awesome. It's great. The kids can learn it and whatever, right?" And she said, "Look, she goes, this is really good." And she went, and I lost my
Oh,
ever
no.
loving mind.
Do I even want to know what that means?
Hungry,
Yeah.
horny.
Oh no! No!
She told the pastor she's doing this.
Oh.
She goes, "Well, I'm very hungry, so I thought you repeated it." Like, no. Very hungry. I don't know how she and the doctor didn't bust a gut. Yep. Do you know what that means?
What does that mean?
There's this and there's this. This looks like, or you can do it this way, shaving, right?
Mm-hmm.
Sex. Propositioning. Yeah, we're going to get demonetized anyway. So
Oh, I think that the beginning of this stream demonetized the stream.
Why?
Oh, wait, not this stream. That was last stream.
Because of that. No, that video I played.
Yeah. Was that this stream?
Oh,
yeah.
I don't care. But it, so you got to be careful with sign language. You're right. Just this is retarded. Now, we don't use that much anymore.
Yeah.
But rhetoric, like the rhetoric of the government, is this.
Ooh.
Although they're both the same. I was signing the song Love in Any Language by Sandy Patty, and I was nervous, and there's a bunch of deaf people down there, and I signed retarded instead of rhetoric.
Oh.
And the deaf person came up to me and she goes, "Do you know what? I know you were nervous." They were friends. And I said, "I know I accidentally signed the wrong thing." And she goes, "Really? I don't know why there's a different sign. The rhetoric is retarded."
There you go.
Okay. I know, isn't it horrible, y'all? We're so horrible. We're so horrible. And
I still
ladies,
can't get
don't
over.
sit like this. Men, don't sit like this around a deaf person.
Oh,
Braxton,
no.
don't sit like this.
Yeah. Okay.
So if you're sitting in a room of people and you're doing this, or yeah. It's one thing if you're in your home. If you do it like this, or like this, or like this. But if you were in this position, or in this, in a room of people you don't know, don't do it. Especially if there's a person.
Oh, that's.
Or when people do this.
Mm.
I guess you can guess what that is.
I think I can.
Yeah.
Oh no.
And I love it when you're signing and it's a class and they start talking about things that happen to people, body parts when they age, and some of the difficulties they're having. And they bring up the problem that men sometimes have, and I had to sign the word.
Oh no.
Oh, I did it way down here. I mean, I'm signing up here, but I dropped it way down here and I did it quick. So, because everybody goes, whoosh.
Yep. They're like, I need to know this sign.
Yeah. I was at a Women of Faith conference and the woman was talking about mammogram. And the big screen was behind me and the whole time mammogram. And they had me on the big screen. And she was stuck. So you're going, I'm not doing with this but she was, I mean, it was full blown.
Yeah.
That's what we have to do. Y'all, it is not easy being an interpreter.
No.
Loser. Why is loser your favorite? Some people get it wrong. Some people do it wrong and it's something else. So that's why I'm asking. Why is loser your favorite? Well, it ticked me off when my mom taught my daughter. I was like, bitch.
What does that mean?
Loser, whatever. Now that's true. What is this way or what? But that was, yeah. That was the first thing I learned dating a guy. Stupid. Y'all can use this. Stupid. Okay. I think we beat that subject to death.
Yeah, right. I know it's not sign language, but I remember I was on RA's stream and I just did this and didn't realize at all what I'd just done. You understand, right?
All right, tell them.
Well, I believe it's French. I believe it's France and the British.
This is what really not whatever. My mom didn't know. She knew that was loser, and then she taught my daughter W for whatever. 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 This is really the sign for whatever. Doesn't matter. Whatever. So I would do. But it was just what my mom taught her. She did it so much. I was like, break your fingers. Mom.
I'm
going to go see her tomorrow.
It comes all the way back from 1415, where English archers supposedly showed their fingers to the French to indicate they could still shoot their longbows. Yeah, interesting.
That's 2 in sign language.
1,
2, 3, 4, 5, 6, 7, 8, 9, 10. 10's this way. You can count to 1 billion trillion on with one hand. And this is his helper. 1,000, million, billion, trillion. 152,322,421.52.
Jeez.
So the first one, a slang your mom taught you, then caused you and I to never see the sign of the way. Huh? It's the first one. Oh, she taught my daughter, not me. And she didn't know whatever. So she go, loser. And then she may go to loser, whatever. Oh, it was horrible. Basically, that's nothing. That's why.
But it's just fun to do.
Yeah, not at 2.5, 3. And there's no self-control.
Oh, but it's fun for the grandparents.
Yeah, payback is going to be fun. So tomorrow we have absolutely nothing on the docket.
All right.
I'm going to be traveling for. She didn't until she came back. But I'm going to be. I think she saw some movie with a little girl that had this little attitude-y thing, and that was the end of it. It didn't last long when it came back to my house, though. But so we'll probably try and do something Wednesday. I really hope Rob and Ian has their thing come Friday night, because I'm getting pissed, man. I'm all ready to interpret, and it's like 5 minutes before. Oh, we're not doing it. I'm like,
this is Mr. ADHD Rob.
Well, he was moving and didn't get set up. I thought it was pretty adventurous for him to think he was going to get all that done in a week.
Oh, yeah.
And be in court and have a job. And I was like, good luck, dude.
Yeah, right.
Unless he's paying somebody to do it, then it could get done. So what are you doing now? Are you still scanning?
Yes.
Well, guys, what time is? Oh, geez, is that what's left? Is that all of them or what's left?
No, this is what's left.
Okay. Well, it's 10 o'clock, or 10:15 my time. I got to get up at 5 in the morning. How many in a box?
133 in each box.
Oh, okay.
This is about $3,000. Wait. No. Now it's $3,000.
Somebody asked, what are you scanning?
Magic cards.
Is it a game?
Yeah, it's a trading card game.
Well, that's cool. Everybody,
Yeah.
I probably have that much in beads. I got to get to work on this stuff. I've not been beading, so I got to start doing that. Oh, I love that game. I've never played it. Never saw it. Never heard of it.
Magic the Gathering.
Cool. So, we may do something Wednesday night or Wednesday during the day. I don't know. We'll do something. I'm sure something is going to pop up. If something pops up while I'm gone, when I'm driving home, because my phone mounts, I won't be looking in the camera, but I can go on and we can talk about it. But Friday, we're definitely going to go for the Friday Night Frenzy. And then Saturday is going to be our Saturday night Spilling the Tea. I need to get a guest. I miss the camera they used to have with it. What camera? But as always, y'all are awful. You're just awful. You're awesome. But I'm going to have to get up like at 5 a.m. to be on the road and get where I'm going by 11.
Yeah. I've got to get to work at 8 o'clock tomorrow, so.
I can sit and drive all night long and stay up all night long till 10 in the morning. But if I go to sleep and have to get up and drive at 5, 6 in the morning, it's so hard.
Yup.
So, Braxton, you said so you had some ideas for me, and we haven't talked about those.
Yeah. Busy stuff. We'll get together later this week.
Yeah. We just need to start gearing up for when I get that switch. I hope you know how to use it. If not, you can help me figure it out.
I have no idea. That is black magic to me.
But you can help me figure it out.
We will see.
Everybody's
might be on that
end of this month. Guys, please, anybody's here who can do logos. I desperately, some of you are new here, so I'm going to go ahead and run this. I gotta run something. I want to feel like I accomplished something. So I'm going to run it anyway. So let's go. Well, guys, it's that time. We need a logo, we need merch, and a website. So I decided to have a competition. The person who creates the winning logo will get a t-shirt, hat, and a $50 gift card. And the logo will be featured on everything that we have: Facebook, YouTube, Twitter, Twitch, the website, my email, all the merch. So if you're interested, deadline's August 15th. The winner will be announced on the 1st of September. Thank you so much and good luck. So, guys, I was glad we were able to come on and actually watch the hearing.
Yeah.
That was awesome. Although by the time it was over, I was ready to put her in a suitcase and zip her up. Eye for an eye, tooth for a tooth. That is biblical, isn't it?
Case closed.
That made me laugh. I don't mean.
Oh dear.
Braxton, are you okay?
Oh, I exist. That was great. Alrighty then.
I have to say, my favorite of a lot, one of my favorites is,
Oh my God!
Yes.
No. Oh my. No.
and then, where's the one about the money?
All I ask is a chance to prove that money can't make me happy. When all else fails, read the instructions. When all else fails, read the instructions.
I thought of you when I downloaded that.
Yep.
And why are you looking at me like that? I read the instructions.
I wasn't looking at you. I was honestly looking at the internet.
Look.
All right, let's just admit it. That didn't happen.
About life. Just gotta let it happen.
I don't know.
I
I
think
had
we're
some
both very
fun.
tired.
Huh?
I think we're both very tired.
Well, yeah, but I've got to get my stream back up and running because my good ones like when now let me ask you, EDB, every time she says FBI, you hear FBI. Is it picking it up from when she says it?
I have no
Or
idea.
she
I haven't
pushing
watched
it?
her streams in a while.
Well,
Oh.
I'm gonna get one so I can push the buttons. Yeah.
Nice. Yes.
Objection. I object, Your Honor. I'm going to record my own because I can do this.
I object.
Overruled. I said overruled.
Have to turn it in.
So we need to fix that. When the voice goes too high, it starts clipping out.
Yeah, I noticed.
So I'm talking about like this.
Mm-hmm.
Mm-hmm. I understand, but I have a question. Then you don't understand, right? You can't say understand, but I have a question and still understand.
What's the question?
She doesn't know.
Oh.
Sarah Boone just talking out her ass.
Yes.
Telling time so she doesn't have to go back to that jail cell. She keeps asking questions about things that the judges already told her no. And she keeps saying again and again and again and again and again.
I said, hell no. Denied.
Yeah.
Shut the hell up.
All right. Well, I have got to start to get back.
I've driven Braxton crazy. I haven't watched a lot of her. Still new to her channel. Yeah. Well, this was all about Sarah Boone, what I was talking about, because she's all over the freaking place and she doesn't take no for an answer.
Yep.
I wanted to say to her,
Ma'am, what part of declined or no do you not understand? And you want to represent yourself? Why don't you just write your ticket to the death penalty? You know, just write your own ticket. Easier and cheaper.
Not wrong.
everybody's laughing. See, that's what I'm about. I'm about that. I want to make people laugh before I go. Okay.
Oh,
and Braxton's like, I'm just ready to get the hell away from you.
I'm just ready to go to bed.
I don't think she gets the part of she was drinking, so she was under the influence, even though she said she wasn't drunk.
If I'm walking and I'm talking, I ain't drunk. And if he's breathing and he's talking, he ain't dead. I didn't do it. He was still alive when I left him.
I don't know if she claims that or not, but everybody does. You know, he was still alive when I left him.
Yeah.
All right. So with that, we're going to get the heck out of here.
Sounds
Braxton,
good.
as always, you are a love. Everybody loves Braxton. I feel like you're kind of like, I don't know. Well, you're the IT man. That's for
Right.
sure. But, everybody enjoy the day off tomorrow.
Yeah.
I'm not looking forward to this. I gotta be honest.
Yeah.
It's just, I'm tired already. We had that crazy man in the shop.
Yeah, that was.
I haven't been able to sleep.
I don't blame you.
Every time I go to sleep, I have dreams that I'm getting in a gunfight or blowing somebody up because they come in with a gun and trying to do stuff, you know.
You know what's interesting? What night was it that we? It was 2 nights ago that we did the stream, right?
Mm-hmm.
I had a dream about someone breaking in as well. I just remembered that. Interesting.
Yeah, well, you know, our towns, we never had murders. We never had gunshots. I mean, it was, and then COVID came, and after then, I mean, just in the last 3 months, we've had 4 or 5 people killed through, you know,
Wow.
a weapon of being a gun. And we had a lot of murders lately, and I mean, 25,000 people. It used to be quiet, and it ain't so quiet no more.
Yeah.
Oh, I love this. We're all going to hell if she's found not guilty. Yeah, he's the only testosterone in the room.
You know,
all right, Braxton, don't be mean. I'm not gonna. This is a joke because I cannot leave that hanging. He's the only testosterone in the chat, and there ain't a whole lot of it.
That's fair. But you know,
he's young.
So
actually, there's more testosterone when they're young. When they're old, there's not a whole lot left.
I grew up with a single mother, with female friends, with daughters. I'm more comfortable around women than I am with men.
I get it.
Like,
get it?
100%. I'm more comfortable around women. Men are complicated.
I grew up being around older people.
Yeah,
I'm still
same.
not comfortable with people who are my age.
Yeah.
Younger, older, we're good. My exact age, I never was around anybody my age because of my parents' church. It was an old church.
Yeah.
And it was either baby or old, and we were the only teenagers, me and my twin.
Yeah.
Watch out, Brett. No.
Keep
it clean.
I think I'm the only guy that has said this. Men are complicated.
I thought women are worse.
Not to me. I understand women fairly well because men are very complicated when you haven't been raised by one. And you haven't really had any in your life. Like, seriously, I was raised by a woman. There were not a lot of male friends, or
there wasn't a male role figure.
No good ones, at least.
Yeah, role models. Yeah.
I mean, you can disagree with me.
As a mother, okay, as a mother, boys are easier.
No, yeah, 100%. Don't get me wrong.
Well,
boys
actually,
are easier.
Girls are easier until preteen. Then all hell breaks. No, actually, I got lucky with my daughter. I really did. Compared to most moms, my daughter was a saint. Both my kids were. I totally agree with Ada. Yeah. But I get his point. If you
Yeah.
were raised around all men or all women, that's what you're going to be comfortable with.
And
it
even if
all
you were
depends on the
raised,
girl, but
even if you were raised by two parents, there's a lot more testosterone influence. I had none. Like, I went to scouts.
True.
I had some stuff, but truly, I find men complicated. I have a tough time working for them and with them. Like, I have a trouble in my professional life understanding how to work with men because I
I've
don't
been
know how.
talking to your grandpa quite a bit because he can help you with that.
Oh yeah, but I just don't understand them. I understand how women think. I don't understand how men think. Like,
Well, there you go, Ronnie.
yeah.
Yep. I'm lucky I had one of each, and I did have a father and a mother. I was adopted, but I did have a father and mother, and I had a twin brother. There was 2 males, 2 females. It was equal balance in our home. Until
Yeah.
my brother became a full-blown teenager, and then he became an ass.
Yeah, sounds about right.
Yep.
We do that.
Okay, y'all. I got to get home and be in bed by 11. Y'all are amazing. You make my day. I can't believe I literally have been on 4, 4, 8, 9, 10, almost 12 hours today. I've
Yeah,
only
I
had 2
know.
short breaks.
You've gone live 3 times.
Well, but it was like we were waiting. And then there was, oh, I'm not going to be able to go live tomorrow. And I promised I was going to talk about this. And then I
Yeah.
got off, I went and grabbed dinner, and I come back. I didn't even get to eat dinner. I sat down at my TV in the office. I put my legs up. I had my drink. I was getting ready to eat, and I turned on YouTube and went, shit. And I come running in here.
It was really funny. Literally, the last chat in the last live stream was Court TV just dropped Sarah Boone, and that was by Sneaky. Like, she put in the chat after the stream had ended, hey, they just dropped Sarah Boone.
I didn't see it.
Oh, I know. I thought it was hilarious. You ended
Why
your
the hell
stream.
didn't you text me? You have my freaking number.
I thought you
I would have run right back. Boy, you're slipping on the mod job. You're great with teching, but you're slipping on the modding.
Well,
Ronnie, I need you to send me your photo. I'm getting photos of everybody. I don't know why. I click on your picture in the little circle and it won't download. I need your photo, love. I want everybody's picture of everybody. I'm doing something. All right, guys, it's good night.
Yeah.
Braxton, you've been a doll. Thank you for your support. You guys, he's constantly throwing out memberships and stuff, and it's so kind of you. We do need to grow the memberships and all the super chats and all that, but we'll get there. We'll get there. But
does anyone in the chat not have a membership?
Are you shit?
Like, right now, at the very least.
Ronnie doesn't. Oh, Ronnie's the only one in the chat that doesn't. I think it's just Hazelnut and Ronnie in the chat right now.
One moment.
We had 37 in our members only. Oh, you are so Braxton.
Yeah.
What? You already know who got it?
Yep.
It tells
Ronnie
you
has a membership. Yeah, it says
it didn't tell me. Oh, there it goes. It just jumped up. Yay! Woo-hoo-hoo-hoo. Ronnie got a membership. Ronnie got a membership. Thank you, Braxton. You're so awesome. You really are.
Yeah.
All right. Braxton, thank you. Ronnie, you'll be a part of our membership lives. I opened it up for all members because I'm trying to get people used to it.
Mm-hmm.
I can pick what level.
Oh.
So last time I opened it up for everybody because I thought, you know what? It's not fair at this point.
Yeah, no, I think everyone should be able to.
There will come a point though I will be limiting it. I mean, you'll have to come in at the $4.99 level.
Well, everyone I gift a membership gets the $4.99 level.
Oh, you're so kind. You're so
I don't get a
sweet.
choice.
Really?
YouTube doesn't let me choose.
Oh, well, at least it's not telling you the $19.99 one.
Right? Yeah, exactly. But
You'll be doing a whole hell of a lot less. Braxton,
we
put your
have to edit
cards
this.
away. Stop scanning. Go get a shower. Brush your
Yeah.
teeth. Wash behind your ears. Get your PJs. You do wear them. I'm not going to ask. And go to bed. You got work in the morning. I'm being a mama.
I think I actually have some Taco Panda pajama pants. They are pandas sitting in tacos riding through space.
Oh my God. Oh, Hazelnut, and don't sign bad words. And if you're mad at a man at work,
Yeah.
okay. Those are my kind of PJs. All right, guys.
Right.
Out. I got to
Good
go
night.
home. Love you. Good night.
Bye.
Bye, Braxton. You guys, thank you so much for a fabulous day again today. Y'all are so much fun, and I enjoy having you here. This was a impromptu fun night live. Normally we don't get this crazy, but you know, it is what it is. I appreciate all of you guys so very much. Y'all have a great day tomorrow. I will see everybody on Wednesday. And if something pops up cray, then we'll be on tomorrow somehow, somewhere. I'll be mobile. But in the meantime, sleep well, hug your loved ones, give them a kiss. Tomorrow is never guaranteed. So don't go to bed mad. And just get a good night's sleep, because that's where I'm going. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.